Mr. Prince, Princewell, can you hear me? Okay, unmute yourself. Unmute yourself, Mr. Princewell.
Mr. Iwafo, Princewell Chinal, can you hear us?
Yes, I can hear you. I can hear you.
Okay. There's another person with name Chibo.
Yes, that's the first claimant.
Huh?
Okay, that is our fourth witness, my lord.
Your fourth?
Yes, my lord.
Your fourth. If it's the fourth witness, then it's not listed as a party.
Are you sure?
Not listed as a party.
No, my lord. It's not.
Then you should not be in attendance at this moment.
As the court pleases. Mr. Chibo. Mr. Ebuka, Chukwebuka, please, can you leave the meeting now? Okay, he has left. My lord, he has left. There.
The one present, is it the one to be? No, there are still two of them.
Okay.
There is Chibo and there
Mr. Chukwebuka, please, I want you to leave the meeting now. We'll still call you. Yes. Yes, you should leave. Yes, leave, please. We'll call you back.
I should leave. But he's there.
Please leave. We'll call you
back.
back.
Have to disconnect when we are done. Please. Then we'll call them. Okay. Because he's sitting with and the claimant is present. We recorded him as absent.
Okay. Joy, you have to leave the meeting.
Do I have to leave?
Yes.
Well, you have to leave because the fourth witness is with you.
Okay.
So you have to disconnect.
Okay.
When we want you to join, your counsel will call you to join.
Okay, ma. Thank you.
Okay, so you have to disconnect when we are done with the third witness.
Okay, ma. I'm disconnecting, ma.
Okay. Just because the fourth witness is there. Mr. Wafo.
Yes, my lord.
You remember your oath?
Yes, my lord.
Or rather, you're an affirmation.
Yes, my lord.
Mr. Mario. Please, I would have said 20 minutes. But let's make it, yes, 20 minutes should be okay. For this week. Okay. Please go ahead. Yes.
Good afternoon, Mr. Wafo.
Good afternoon, counsel.
Your evidence in this case is that all the facts you deposed to were derived from your personal knowledge. Do you still stand by that statement?
Yes, counsel, for the most part, all the facts I deposed to here are derived from my personal knowledge and the information that was relayed to me in the course of my interface with this matter. The information I came across in the course of my interface with this matter.
Okay.
During your interface with you.
With this matter. With this matter.
Okay.
Now, are you familiar with the consultancy contracts that the disease enter into?
I have seen the contract to the extent of what was annexed by the defendants. I've seen the contract to the extent of what was annexed. I've read it to some extent. So to that extent, okay, I'm aware of the contract. I can say I'm aware of it.
And are you aware that under this contract, the disease was engaged as an independent contractor to provide medical services with a fixed tenure of 12 months and not as an employee? Are you aware?
Number one,
are you aware,
document.
sir?
Yes, I'm answering your question. Please, may I answer? I have two answers. One, the document before the court speaks for itself. The annexure, that exhibit speaks for itself. That is one. Two, I am aware that by virtue of that contract, that document, that contract, that the first defendant recruited the services, the medical services of the deceased for and on behalf of the second defendant. So I am aware that the medical services of the deceased were recruited contractually by the first defendant to provide stated services for the second defendant. That I am aware.
My question is, are you aware that he was recruited as an independent consultant and not as an employee? True or false?
I have stated what I am aware of, Counsel.
Very well.
What I am aware of is what I have stated.
Very well.
Counsel.
And are you also aware that the disease was, or under the contract, the disease was informed that the transport arrangements, on-job safety, security will be provided by the second defendant?
What I am aware of, Counsel, what I am aware of is that the first defendants recruited the medical services of the deceased.
My question
and
is,
the
are
services,
you aware? Please, can you please listen to me, sir? Can you please listen to me, sir?
Yes, sir.
My question is, are you aware that under this contract, the disease name that the arrangements for job security, job safety, security, and transportations are to be provided by the second defendant? If you are not aware, say so, sir.
Can I state what I am aware of to that extent, in that regard? With respect to your question, Counsel, what I am aware of is that the first defendant recruited the services, medical services of the deceased. And these services are to be provided for the second defendant.
Very well.
The deceased provided such services. And accordingly, first, second defendants are liable to the deceased. That
I'm
is
not
what I am
asking
aware.
Questions of liability, sir. I'm referring you to paragraph 12 of your witness statement. When you said
I'm merely
specifically,
stating what I am aware of, Counsel. What I am aware of. Okay.
I'm referring you to paragraph 12 of your witness statement.
Okay.
Where you specifically mentioned these issues. You said defendants, plural, are responsible for all the issues relating to on-job safety, security, and transportation. So since you are the one that raised these issues, that's why I'm not asking you that. Are you aware that under the contract, this issue was allotted to the second defendant?
I am aware that both defendants are jointly and severally responsible for this.
You refer
I'm aware
to
paragraph 12 of the witness statement.
I am aware that by virtue of this paragraph 12 here, the defendants jointly and severally are responsible to the deceased in respect of his on-the-job safety, security, and transportation.
I take you to your paragraph 13.
Yes.
Particularly paragraph 13B.
Yes.
You said the defendants, in trying to cut corners and reduce operational costs, engaged a substandard boat for the transportation of the late Ikena.
paragraph what?
13, my lord. 13B.
13.
B.
Yes.
Since you're making this allegation, can you tell the court the role that the first defendant played in engaging the boat?
Once again, I say the documents before the court, number one, the document before the court speaks for itself in terms of the contract between the defendant, the deceased, and the defendants. That's number one. And in that regard, the defendants being jointly and severally responsible for
Mr. Wako, please. Mr. Wako, please. I
answer your
have to stop you here. My question is direct.
He has answered. Yes, he said the document
is
very well. Now, what was the operational cost that the first defendant devoted towards transporting the deceased? You said you are trying to cut these costs. Can you tell the court the budget of the cost?
Now, in answer to this question, sir, I would want the court to take cognizance of the last exhibit in this matter, being the letter dated 11th June 2021, that was signed and emanated from the CEO of the second defendant. That is the letter that was written by her a day after the accident or the incident, on the 11th day of June 2021, a day after the incident that occurred on the 10th of June 2021. It was in that letter.
The question was, what was the operational cost that the first defendant devoted to the disease?
Thank you, my lady.
The
Because
operational
the
cost,
allegation made there, he said the
Yes,
defendants were cutting costs.
that is what I'm trying to do.
Mr. Welcome. Your response is what? You're referring to what exhibits?
Okay, my response is that the operational cost is manifestly, deducible, manifestly deducible from that letter, explicitly, in the sense that the CEO of the second defendant immediately stopped the use of a smaller, low-cost boat and directed the use of a bigger, more sophisticated vessel that is fit and proper.
Your response is the operational cost is manifestly deducible from the letter of the CEO of the defendant.
Yes, that letter dated 11 June 2021, where she immediately stopped the use of the low cost, of the cheaper and low cost boats unfit for such transportation, for that sea movement, and directed the use of a bigger vessel, bigger, more sophisticated vessel, fit and proper for such water transportation. So the difference is between, I cannot tell you the exact figure, but obviously there is a smaller vessel that is cheap, unfit for the purpose, which she acknowledged on that 11th and said, stop the use of it immediately.
Mr. Walker.
And start using that of a bigger, more sophisticated vessel.
Mr. Walker.
Fit and proper for the purpose. So,
yes, I have noted it. I have noted that.
Mr. Walker, the court has noted that.
Thank you so much.
Did this letter reference the first defendant at all?
Sorry, please.
This exhibit that you mentioned,
yes, sir.
Was it issued by the first defendant, or did it mention the first defendant at all?
The document speaks for itself, sir.
Thank you very much.
Yes.
At that same paragraph 13b, he said, through a channel known to be particularly turbulent at that time of the year. Can I ask you?
Paragraph now.
The same 13b, sir.
The same 13b.
Yes, my lord.
Okay.
Mr. Uwafo.
Yes, sir.
Which channel are you referring to here?
Now, by virtue of my participation in the second
Excuse me, sir.
meeting,
Excuse me, sir. Because of our time. Which channel does he have a name?
That is what I'm trying to explain to you. I am not an expert in that field, but I am relaying to you the direct information obtained in the meeting of DPR. I participated. We respect.
That is hearsay, sir. Please, let's stop it there. That is hearsay.
No, sorry. It's not. He said he participated in the meeting. He participated
in that meeting.
Not hearsay. Allow him to answer your question.
Please.
Yes, witness. What's the response? He said, which channel
that channel is off Ajapa. that Ajagba oil field, off that Ajagba oil field. And it was clearly the meeting, the report of that DPR, that formerly DPR, now National Nigeria Upstream Petroleum Regulatory Commission. It is a known fact, it is settled, notorious fact that that particular water channel at a particular point in the year, around June, becomes very dangerous to navigate. It is very notorious and settled fact, as can be evidenced in the report and the proceedings of that panel.
Okay, thank you.
Of that panel, that channel is notoriously dangerous to navigate at that point of the year with a small boat, the same as the defendants deployed for use by the deceased. That such boats are not fit and proper for use to navigate that channel off that Ajagba oil field, oil well, at that material point in time or that period of the year when the water volume has peaked. So it is notorious to all the players in the field, including the defendants, that it is a matter of life and death to deploy such substandard boats to navigate that axis, that channel, at that material point in time in the year. And my Lord, with your kind permission, my Lord, may I add, with your kind permission, my Lord,
yes,
may I add that it is on record from the proceedings in that panel that that boat is not just substandard and unfit, but that boat was outsourced. It was a boat, the use of which was outsourced to locals. The defendants outsourced to the locals the duty of deploying or using that boat to convey their staff.
Sorry, sir. When you say the defendants, when you say the defendants outsourced, just a minute, sir.
Outsourced the use. So they said, defendants say that the locals have been bothering and disturbing them. So in order to compensate the locals and do something for them, they now delegated to the locals to provide them with the services of such local and substandard boats to traffic, to navigate, or to carry their staff through to and fro workplace. So it was in a bid to compensate the locals and use a very cheap method of transportation that the defendants decided not to comply or to use the proper and fit.
Okay, let's stop you here. I have recorded that off Ajagba oil field as obtained in interaction with the NUPRCS is notoriously turbulent to navigate at that time of the year and should not be navigated with such substandard small boat. It's on record that the defendants outsourced the boat to locals. Okay. Please, your next question.
Thank you very much, my Lord. Just one more question. In your evidence, you said that the vendor neglected to pay a condolence visit to the family of the late Ikena. As a law practitioner yourself, you understand the meaning of negligence, duty of care, breach, consequences. Can you please tell us where in the consultancy contracts or under law, where they have that duty of care to pay a condolence visit?
Thank you so much, Counsel. I am not aware that it is expressly stated. I am not aware that it is so expressly stated in the contract. But I am aware that the parties are all humans. I am also aware that even the second defendant hails from the same state with the deceased. I am aware that the deceased died in the employ of the defendants. And I am aware that the deceased have been trying to show some apparent remorse. And that I am aware that it is human. It is human. It is in line with propriety that a boy of 29 years old, being a medical doctor, that
I'm not asking for a lecture on human relationship. I said, where is it in the contract?
For my legal opinion. You asked me for my opinion as a legal practitioner.
Yes, I said, where is it in the contract or under law? Those are the two issues I mentioned to you.
That is exactly what I'm telling. Law is not just within law.
See the response I have recorded, Mr. Mr. Wap. So what I hear to that question, your response, I'm aware human should pay condolences in such circumstances.
Yes, my Lord. That will be all, my Lord. Thank you very much for the time. Right. Thank you very much, Mr. Wap.
Any re-examination of this?
Mr. Counsel, you seem to be in a hurry to let me go. I have barely scratched the surface, Counsel. I don't know why you seem to be in a hurry to let me go.
My Lord, no re-examination, my Lord.
Mr. Okay,
yes, ma'am. Good afternoon.
Good afternoon, sir.
Yes, my name is Ifeanyi Okechukwu, and I'll be taking you on the next round of cross-examination.
Thank you, sir.
Yes. Well, we know that you're a lawyer and that you are not used to be on the other side. You are used to be by this side, of deciding as the president of the Customary Court of Appeal. So please, we would desire some conciseness, in your answers, so that we can quickly wrap up cross-examination today. Now, please, can you confirm to the court that you were never and also not an employee of Britannia U? That is the second defendant or the first defendant.
If I understand your question, my answer is I was never and I've never been an employee of any or both of the defendants.
Thank you.
Yes.
Yes, and also by the dictates of your work, which is seemingly busy. You were not on that boat or around the area where this incident happened on the 10th of June 2021. Can you confirm that, please?
To the glory of God, I was not on that boat. And I'm grateful to God for that. Neither was I around that area at that material point in time.
Okay, so are you aware that operations in the oil and gas industry, particularly in the upstream, are well regulated and have regulations and guidelines by which players in the industry must abide by? Are you aware?
I believe so.
You said that players in the oil industry.
Yes, my lord. Oil and gas industry, particularly upstream.
Players.
Players.
Are regulated.
Yes, my lord.
Are regulated by?
Regulated by statutory bodies like URPE.
Okay, just are regulated.
Yes.
That's yes.
Okay. Are you also aware that because of such regulations, that written regulations, that is regulations that are written down and issued by bodies such as the NURP, that is the former DPR, that is the Nigerian Upstream Petroleum Regulation Commission, then NIMASA, and other regulatory agencies from time to time issue guidelines and regulations for operations in the industry, including the kind of boats to use for operations and also concerning the safety of personnel. Are you aware?
I believe so.
Thank you.
Can you just read it? I believe that I am aware. Yes, Mr. Okechukwu.
Yeah, there are written regulations and guidelines are periodically issued by regulatory agencies such as the Nigerian.
Periodically.
Yes, madam. Nigerian Upstream Petroleum Regulatory.
Are periodically issued.
Yes, madam. By
regulators such as.
Yes, madam. Bodies like the Nigerian Upstream Petroleum Regulatory Commission.
Nigerian
Upstream Petroleum Regulatory Commission. Nigerian Maritime Administration and Safety Agency.
Yes.
Yes, madam.
And that's this and this. Yes.
So when you say that the boat that was used for the crew change on the 10th of June 2021, when you say that that boat was substandard, can you point to us any specific regulation on the type of boat to be used for short voyage? Do you have any of such regulations specifying the type of boat to be used as issued by the bodies that I've mentioned regulating short voyages? Do you have any of them, and what does it provide?
Okay, thank you, Council. My answer is in two prongs. Two. One is a matter of res ipsa loquitur. Res ipsa loquitur, in the sense that that which a party has admitted requires no further proof. And that admission and acknowledgement of using the wrong boat was made by the second defendant in the last exhibit, being the letter written by the CEO on that 11th day of June 2021, wherein she clearly admitted that the boat used earlier was not the proper boat and directed the use of the proper boat going forward. That is a clear, unambiguous, manifest admission of doing the wrong thing and using the wrong vessel and boat by no less a person than the CEO of the second defendant. Just a day immediately after the accident happened, on the 11th day of June 2021, after the accident on the 10th day of June 2021. So that is a clear admission of guilt and of complicity on the part of the CEO of the second defendant.
Your Honor, I think that point has been made quite clearly.
Yes.
So you don't need to be repeating yourself.
Secondly, no, that point is the summary, it is the gravamen, it is the pivot.
It's okay. It's okay. Please proceed to the next one.
Witness. We have recorded it.
Yes, it is very necessary to emphasize that, yes. Please, my lord. Secondly,
okay, there's a
second arm of my answer to your question is that it is the finding made by at the meeting hosted by the Nigerian Upstream Petroleum Regulatory Commission, NUPRC, in Warri. That meeting was held in Warri.
Hosted by
Nigerian Upstream Petroleum Regulatory Commission, formerly Department of Petroleum Resources, DPR. They hosted that meeting after this incident, where all the parties, including myself, I was there physically present, representing the plaintiffs and the deceased in this matter. And it is a finding made by that body in that meeting. It is a finding made by that body in that meeting that the defendants deployed the use of a substandard boat, which ought not have been used for that purpose. And my lord, may I add, with the kind permission of my lord, yes. May I add that in the words of the chairman of that meeting, chairing the meeting. Incidentally, I've forgotten the name, but he's our brother from the north. He stated it clearly that if it were within his powers, he would stop the second defendant from operating in Nigeria. We will withdraw the license of the second defendant for serial and a track record of breaching the standard and the stipulated mode of operations. Because the second defendant has a history of doing this, and there have been casualties, there have been fatalities in the past. And the chairman made it clear that if it were within his powers, he would withdraw the license of the second defendant for brazen dereliction, brazen affront, and insistence on not following the protocol, on the following the procedure, resulting in fatalities. That was the finding. That was part of the findings of that meeting. And
Are you still there?
Okay, it's all right. We've heard you. We've heard you about the findings.
My Lord, I will crave that there should be a subpoena. There should be a subpoena.
Please. Your Honor, please. You're a witness. We know that you're a lawyer, but your lawyers are here.
This is a personal matter.
Please, I'm the one asking you questions. We have allowed you enough to say what you wanted to say. Please. I am the one asking you questions. Your lawyers are here.
I'm so sorry, Your Honor.
The deceased is my blood relation. He's my little nephew. So I can talk with passion about it. Please forgive me. Kindly forgive me. I crave your forgiveness. I would pray, my Lord, the subpoena.
Now, please, excuse me. Your lawyers know what to do. If you want to give any advice on strategy to your lawyers, you know how to communicate to them. And a senior advocate is leading your team, so he's sufficiently and eminently qualified to map out strategies in prosecution of your interest. So please, you have said a lot of things. You have talked about meetings and findings that were made in meetings. Do you have minutes of this meeting before this court? Did you tender minutes of this meeting before this court? Do you have the minutes?
Thank you so much, counsel.
Please, it is, do you have the minutes? It is a document. Minutes is a document. Do you have the document minutes before this court? Yes, if you don't have, say you don't have, so that we can proceed. Do you have the minutes of this meeting where these findings were made and all these allegations of consistent breaches were made? Do you have the minutes before this court?
Thank you, counsel, for your question. I will give you an honest answer. The minutes are not before the court presently because attempts made to obtain the minutes from the body, that is Nigerian Upstream Petroleum Regulatory Commission, has not yielded results. Hence, my plea to the Honorable Court to issue a subpoena.
Thank you. Please, Your Honor, your lawyers know what to do as to your plea. Your lawyers know what to do.
That is why the minutes are not there, because they have failed to produce the minutes. Hence, the court, being a court of justice, can issue a subpoena.
So sorry,
Witness, just hold yourself. You have your lawyers here, so they know what to do. They know how to bring evidence before the courts. Yes, go ahead.
Please, I just want a concise answer from you on this question. You can explain. Of course, we'll give you, because we give you an opportunity to explain. At that meeting that you referred to, the second defendant, submit documents of his journey management plans and certification of the boats. If you are aware whether he submitted such document, just say yes that you are aware. If you are not, say you are not aware since you attended that meeting. As a couple.
Did the second defender submit what?
Documents of his journey management plan, my lord.
Journey management plan.
Yes. And certifications for the boat to the fact-finding committee.
Yes.
Are you aware? If you're not aware, say you're not aware.
Thank you, Counsel, for the question. I am aware that the second defendant submitted several documents to the committee. I am aware that the second defendant submitted several documents to the committee, including the letter of 11th June 2021.
Thank you.
Including that letter of 11th June 2021. That I am aware.
Thank you. Please, you have a copy of that letter of 11th June 2021 that you've been harping on. Do you have that letter before you?
It is before the court, sir. Yes. The letter is before the court.
Are you familiar with that letter?
Yes, Counsel. To the extent of the entitlement.
Please. I would have loved that you are with that letter. Over there. I will take. Okay. Since we are familiar with the letter, is there anywhere in that letter, looking at the letter, which we are familiar with, is there anywhere in that letter that the incident of 10th of June 2021 was referred to, and the second defendant expressly admitted that the use of the boat was the cause of that accident? Expressly, as written in the letter.
Thank you, Leonard Counsel, for the question. As I have said before, the letter is before the court. The letter speaks for itself.
So, expressly admitted what?
Hello?
Expressly admitted what?
Admitted that the mishap that happened on the 10th of June 2021 was as a result of the use of that boat.
So the document speaks for itself.
Yes, beloved, my answer is that the document is before the court. The document speaks for itself, and the Honorable Court is at liberty to make.
It's all right. It's all right. The Honorable Court will do what the Honorable Court will do. Please, the next question. Next question, please, Your Honor.
I am not done with the answer.
Please, you are done. You are done.
I'm so sorry, my lord.
Please. I am not done.
I have recorded your answer.
Yes.
My lord, I was saying that the letter is before the court. Yes. The letter speaks for itself.
Exactly.
And please, counsel, and that the Honorable Court is at liberty to make proper deductions and conclusions therefrom.
Of course. So your answer is the document speaks for itself. That's your answer. Okay. Of course, the court will look at all the documents. That's for sure.
Your Honor, please. Are you aware from your participation in that hearing, and from the documents that we have cited, that boat has been used for that operation, similar operation, since 2018 up to that moment. Are you aware? If you are aware, just say you are. If you are not, say you are not aware.
Thank you so much, Council, for the question.
Hello?
When? Since what date? Since
2018, my lord.
Yes, please, Mr. Ward.
Thank you, my lord. Yes, Council, I am aware that the second defendant has been using such substandard boats. From the proceedings of the committee, I garnered that second defendant has been using such substandard boats for their operations over the years. And it has caused fatality in the past. And hence, the second defendant decided to stop its usage by the letter of 11th June 2021. That I am aware of.
Thank you. Okay. So, are you also aware that at that time of the year, which according to you, there used to be storm in that area, that boat was the same boat that took the team that were going on board the rig offshore, that it was that same boat that took them there successfully, and it was on the return journey that there was a storm. Are you aware it was the same boat that went on the journey and that the accident happened as they were coming back? Are you aware?
Thank you, Council, for the question. I am aware, yes, I am aware that it is the same ill-fated substandard boat, which is a matter of life and death, that was used for the journey going and could not make it for the journey coming back. I'm aware it is that substandard boat. And I am also aware from the proceedings of that meeting that had they used a better boat, same as the second defendant recommended and they stipulated in the letter of June. The meeting, the experts that testified in the meeting said if such boat had been used, the storm would not have capsized it and the deceased would have been alive today. That I am aware from my express and active participation in the meeting, that had the second defendant used the proper boat, same as she stipulated in the letter of 11.
You have said this before. You have said this before. You have said this before.
I have not said this one before. Council, listen to this one.
Yes, I have recorded that you are aware. Mr. Okechukwu, go ahead.
As the court pleases. Please, apart from what we heard about alleged similar incidences in the past, do you have any documents? Because if something like that happens, it will be reported. There will have to be documentations to show that similar incidents have happened in the past. Do you have any document at all to show that such inquiries are held in the past and that the second defendant has been indicted, or that he had been involved in such accidents in the past Do you have any such documents pleaded by you before this? Any document at all of such incidents in the past, apart from what you heard? Any document?
Thank you, Counsel. The relevant documents you asked for are with the Nigerian Upstream Petroleum Regulatory Commission.
Thank you.
Can be obtained by subpoena.
It's all right. Thank you.
Yes.
Okay. Please, can you confirm to this honorable court, since this matter is very dear to you and very personal to you, that the life insurance benefit of the deceased had been processed, paid to the family of the deceased? That is your family. Is that correct?
Thank you for the question. I want to believe so, but it is the administrators entitled, administrators of the estate of the deceased, being his father and the mother, that are in the best position to answer that question, not me.
Okay, thank you.
Yes.
Okay, this may be my last question, Your Honor. Are you aware that your cousins, that is the two sisters to the deceased, have been procured jobs, one at Air Peace and the other one at United Airlines, by the second defendant, even though it is not obligated to do so? Are you aware that jobs have been provided to the two sisters of the deceased?
Thank you for the question, Leonard Counsel.
Thank you.
Firstly, the sisters to the deceased are not my cousins, they're my nieces.
Oh, no.
Secondly, I am not aware of such jobs or employment being obtained for them as you alleged. I am not aware.
Mr. Ketu, you said that was your last?
That will be all for the witness.
Any re-examination?
None, my lord. No re-examination.
So you have one more witness. It's past 3.
Yes, my lord. We have one subject to the findings.
We'll take him at the next date. Dr. Sitting here since morning.
God please.
I was even wondering, because manage that's left.
Yes, that's what he said.
You said
He
so.
said
He was not going to. He was going to just make do with the 3 witnesses. Don't know.
Well,
Okay, I'm trying to say something.
well, my lord, I will confirm
Yes.
from my leader.
Give us a date when we come on that day. But we have to be sure so that we don't come and he's not calling the witness again, and then the defense does not start. So if he's not calling, if he's calling the witness, then we'll take that witness on that day. But then, yes, with them, okay.
So if indeed they are not calling,
You'll come with your witness. Okay. So we'll just adjourn for continuation of trial.
As God wills. What?
13th.
13th November.
Is it 13 or 19?
13th.
1, 3.
Yeah,
Not convenient.
Not
Not convenient. I mean, Saturday for trial.
another day. Nineteenth. What of 19th?
13th is a Tuesday.
I think it's convenient. Convenient.
Adjourn to 19th November for continuation of trial.
As
God
God
wills.
wills.
Lord, we therefore yours.
Thank you.
As I was seeing that all of us would like
We'll do what?
for a very peaceful family.
Okay.
But that's
Thank you. I wish you a very restful vacation too, because you will also be resting. You will also be resting.
well, unfortunately, there are some issues with this because we do know that our schedule is not as final schedule. When I think about it, there is one especially for family that was doing I think now